The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
The king of pop or the prince of porn. Prosecutors show jurors everything but their legal briefs. Pretty unbelievable, folks, but you're going to see it right here. Hello, I'm James Curtis, and welcome to E's special one-hour coverage of the Michael Jackson trial. In another unexpected event, Jackson family attorney Brian Oxman falls mysteriously ill, and according to eyewitness accounts, the singer comforted the lawyer as the court bailiff sprang into action, helping Oxman remove his jacket and his tie. Now, Oxman was escorted out on a gurney to a waiting ambulance. Now, the attorney's wife later told the media that Oxman had a touch of pneumonia and is now resting comfortably. But the story of the day still was inside that courtroom in testimony with respect to Jackson's mountain of pornography. Now, before we climb that legal precipice, we go to an aggressive cross-examination of the witness, Louise Palanker. You remember, she's the comedian who helped the accuser's family when the teen was gravely ill. On cross-examination, here's what she told defense attorney Tom Mesereau, according to the courtroom transcripts.
Now, with respect to Janet, you told the Santa Barbara sheriff that any time the got someone's phone number, they would use it, right?
They liked making phone calls.
And who do you know that they used to call besides yourself?
They called Jamie, Chris Tucker, George Lopez, and they called Jay Leno.
And you, excuse me, something in my throat. You told the sheriffs, I have people call me at home and say, what do you want me to do with these people? They won't stop calling, correct?
That was concerning the Jay Leno incident.
Did Jay Leno tell you they won't stop calling him?
He told me that they had left about 3 messages on his voicemail.
Okay, and you told the sheriffs you took David aside and said, stop calling all these people, right?
I said specifically, I've been asked by Jay for you to stop calling Jay.
Next, celebrity leeches or a family in need.
Did you remember telling the Santa Barbara sheriffs, I don't know who's putting the kids up to all the phone calls?
Yes, I do.
And did you say that because you knew that the children were calling celebrities by phone?
I did know they were calling. I didn't know it was Gavin's initiative. Gavin likes to pick up the phone and call people. Or if they were being asked by their parents to do it.
Okay, so you told the sheriffs they would go over to his house anytime they encountered a celebrity if they felt to be important. They would go over the top with cards and phone calls. And at first I thought, after I found out maybe they saw celebrities as a lifeline to get out of her situation, that she had gotten into at 16. Do you remember saying that?
Yes, I do.
You're referring to Janet, correct?
Yes.
You were referring to the fact that Janet got married at the age of 16, right?
Yes, I was.
Married at the age of 16, Howard Weitzman, I can see you just pumping over in that chair because you know what's coming up. We haven't quite gotten there yet with this witness, but what we have so far, Howard, what does it suggest to you about this accuser's mother, rather?
Well, it suggests what we've known all along, at least what the defense's position is. She used her kids and she used the celebrity relationships that her son's illness allowed her to access to get money and to take advantage of the situation for herself as well as the young boy.
Which means you can be leeches and a family in need. They're not mutually exclusive.
Which is really kind of the problematic issues, and we'll explore that a little bit later. Rick, let me ask you a touchy-feely, introspective, philosophical question.
Oh, I love it. Please.
And that has to do with, and this is just my own personal observation, nothing to do with practicing law, just the human experience. When folks do things like get married and drop out of school or go through other big life-changing events when they're very, very young, I've observed with my friends and relatives and other folks, they tend to stop developing emotionally, mentally, intellectually. They kind of have a stunted growth pattern. Do you think that this woman, this accuser's mother, may have got stunted and stopped growing when she was about 16 when she got married and therefore is acting like a 16-year-old now?
I don't know. I mean, I don't know because I have never met this woman. I certainly haven't analyzed her, but I will say this. It does give the defense a theme, and the theme is that this is a woman who's going to say that she had an abusive father, then she had an abusive husband, that she's always been, quote-unquote, falsely imprisoned, and so therefore it gave her another reason to use that phrase against Michael Jackson.
Absolutely. Now, Sean, we're going to get much more into this false imprisonment syndrome. It's risen to the level of a syndrome, a clinically, psychologically, hostage syndrome when we get further into this testimony, but I know you can't. I know you can't wait for
how
that,
does
John.
she get to come up with this hostage syndrome?
Exactly. How does she get to testify to all this stuff? Now, keep in mind, and one of the things is I talked about this with some folk yesterday, the Palanker testimony. Legally, it's problematic, but to the layperson, to the non-lawyer, what's the problem, people say to me, with her testifying to what she thinks? Why is that a problem?
Because what she thinks is irrelevant, and the jury is probably going to attach undue significance to her opinions, particularly when she uses words that sound very fancy and official, like hostage syndrome. They're listening to her and attaching significance to what she says.
Right, and if the jury likes her, if the jury really feels how she cared for this family and feels how she does not like Michael Jackson, that is absolutely clear, then they will attach that kind of undue significance to her testimony, and it's very bad for Jackson.
If they decide...
To me, she feels like she's been coached.
Okay, we're going to explore that coaching issue with respect to other witnesses that she says she had contact with. But if she doesn't like Michael Jackson, does that help or hurt her testimony? Well, we've heard references to the puppet Pinocchio, you know, the guy with the nose. Well, defense attorney Tom Mesereau wants to know who's pulling the strings.
But clearly you were suspicious. These children are being coached to lie, correct?
I was.
Okay. When did you begin to be suspicious that this family was being, that these children were being coached to lie?
Oh, did you say to lie? I didn't hear the word to lie. I thought you said coached along.
Coached to lie.
To lie. I wouldn't make that statement.
Well, you certainly told the sheriff's words to that effect.
Well, that they would stretch the truth as it, when it came to presents or what they had received. That they would say, we got love. What'd you get for Christmas? We got love. That sounds coached to me.
But you thought the children were also being coached by the parents, too. In effect, plead poverty?
No, just that they hadn't received a Christmas gift.
Hadn't received Christmas presents when you knew they had?
Yes.
This whole issue, this phrase, stretch the truth, Ricky, bugs me. It's a lie or it ain't.
Well, no. I mean, I think that you can have the big lie and you can have the little lie, and sometimes the little lie is a stretch of the truth. But I think what happens is
You were not my mother.
That is clear, James.
My
I
mom
was
raised
not
me.
your mother.
It was like, no, you lie or you don't.
But I think this, that when she does talk, she doesn't want to say these kids lied. She doesn't want to say this family lied. And that can make some jurors really disbelieve her, and it can make other jurors sympathize with her.
And I completely agree with you. Stretch the truth, exactly. She's going out of her way to protect these children, and I think the jury is going to find her to be completely incredible because of her bias.
Yeah, I agree with Sean, and kind of disagree with Ricky. She seems to be perpetuating the lies. She seems to be excusing the lies. And one other thing, the fact that this lady was married at 16 doesn't excuse her moral inadequacies.
Well, but it does explain it, or it could explain it, because people don't have a chance to develop when they stop growing intellectually, emotionally, morally at 16.
So
not justifying it,
but they don't know right or wrong?
That works both ways, though. That can work for the prosecution or the defense. The fact that if we accept your premise that she stopped growing emotionally at 16, which I don't know if she did or didn't.
Yeah, we don't know.
But the reality is, for the prosecution, is then she, too, is someone whose children, the way she raises them, who could be taken advantage of.
And then there's that whole sticky wicket, if you will, of the high and mighty, privileged, endowed, financially, celebrities helping out the poor, brown, and downtrodden. Well, still ahead, an avalanche of porn. Plus, did the accuser's father see Louise Palanker, this witness, as something other than a guardian angel?
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. As the cross-examination of comedian Louise Palanker continues, defense attorney Tom Mesereau tries to follow that long, winding money trail. Now, just a program note for you. The Dave and the Janet that are referred to are the parents of the accuser.
Okay. Now, you testified in response to the prosecutor's questions that David, to your knowledge, never paid the repairman who fixed up Gavin's room in El Monte, right?
That no one from the family had paid him.
So it wasn't just David who didn't pay them. Janet didn't pay the person either.
He wasn't paid.
He just wasn't paid, period?
Yes.
Now, you indicated that David told you that Janet had spent the money that you had generously given them.
No.
What did you say about that?
That David told me that?
Yes.
Yes, he did.
And did he tell you what he had thought she had spent it on?
Votive candles.
Anything else?
I can't recall anything else he said.
Well, he didn't really just tell you she'd spent $20,000 on votive candles, did he?
He said she's going crazy and she can't cope with this situation and she's buying a lot of statues and votive candles. I don't remember. It was one big blurry sentence that didn't make a lot of sense to me, considering the amount of money.
And you did tell the sheriffs, in referring to what the had done with your money, they bought him a giant, flat screen picture TV and DVD player. You know, a kid at that point 5 years ago doesn't really need more than a VHS. Do you remember that?
Yes, I did say that.
And were you upset that your money had been spent that way?
I wouldn't use the word upset. I was concerned that they weren't going to be very good at budgeting their money.
As defense attorney Tom Mesereau presses forward, was the accuser's mother a little unstable, and did somebody fib about Santa Claus? How could you do that? A program note, the star you hear mentioned in the upcoming testimony is the brother of the accuser.
Do you remember telling the sheriffs the following? I know that Janet's unbalanced. I think she's totally bipolar. The behavior from the children, from the family, was so over the top all the time. Do you remember saying that?
Yes, I do.
Okay. Do you remember telling the Santa Barbara sheriffs when you were talking about letters you received from the you don't just get one letter from them, you get 5 letters from them. You don't get one phone call, you get 5 phone calls. A message from Janet on your answering machine can last 5 minutes. She mimics types of messages on the phone. You mimicked, for the sheriffs, her messages on the machine. Do you remember that?
Yes, I do.
Is that something you said?
Yes. I was exaggerating. I didn't know I was being taped.
Do you remember responding, it was always David or it was the children being coached to ask me for a laptop?
I felt that Gavin had been coached to ask me for a laptop.
Did Gavin ask you for the laptop?
He would go like this, because I had promised him one, so he was reminding me.
So you were asked by the officer, what do you mean by coached? Do you remember that?
Yes.
And you said, being coached to tell me that they hadn't gotten any Christmas presents.
Starr had told me that, yes.
Did you believe Starr when he told you they hadn't gotten any Christmas presents?
I didn't really. I wasn't sure. A lot of people were giving them gifts at that time.
Did you think Starr was being coached?
I did.
Sean?
Yes?
Help me, please. Is that something you said? Question by Mesereau. Yes, I was exaggerating. I didn't know I was being taped. I'm trying not to scream right now, Sean.
That's
what is this
outrageous.
about?
Well, I don't know what to say myself. It's so outrageous. It's such a ridiculous statement. How is exaggeration something that you do when you're
not being taped, so you can get away with exaggerating? Yes. So how does this work? I'm not sure
Let me take it from the prosecution's point of view,
here?
because I think what they're saying is this. What happens here is this is a woman who goes into an interview. She says what she has to say. She's a comedian by profession. She's someone who is prone to exaggerate. And she doesn't really get it at that point in time that they're taking it down in one form or another and that this might be used at another time. The fact that she admits she exaggerated, I think, is a good thing for her.
But it seems like she's telling the truth. She's telling the truth when she's being taped, and now she's caught with the tape, and her only explanation is, well, I was exaggerating.
And the problem, Howard, isn't the problem that, and perhaps these jurors don't have a sense of this, but certainly you all, as practitioners, must, when you have folks who aren't sophisticated with respect to law enforcement, don't realize the gravity of talking to a police officer during a criminal investigation. Therefore, they're not as precise as they might otherwise be, and they get caught up in that. We see that happen to suspects all the time. Doesn't that same dynamic apply here?
No. She's not a suspect. She's a witness. She's supposed to be unbiased. She clearly has a bias. She clearly wants somehow the prosecution to prevail. She believes Gavin, despite the fact that he's clearly a liar. He's clearly acts entitled. She actually said she was upset and concerned about how they were spending her money. If I was cross-examining this lady, I would have said to her, did you ever ask them how they were spending your money? Did you ever ask them what they were doing with it? She did none of that at all. And she was clearly upset with the way they conducted themselves. She really doesn't like Michael Jackson, however.
And we're going to
But
see...
she really does care about this family.
She seems to care about that family. Is that caring or the dislike? Are either of those misplaced? Next, the witness seems to pick a side in a nasty custody battle.
You believe Janet more than David, right?
Yes, I do.
Okay. You weren't a witness to anything going on in the home, were you?
No, I wasn't.
Okay. And when did you last talk to David?
After, if you have it on record, when he lost custody of the children, right around that time period.
Okay. And did you used to discuss their marital problems with Janet?
He would make comments, but he only called me after he lost the custody battle because he wanted to tell me that everything she said was not true and everything he said was true. And I didn't want to be involved in that type of conversation.
Do you remember telling our investigator that with regard to Janet's claims of David's abuse, a lot of things said by Janet didn't seem to match up?
I don't think I meant it in terms of the abuse.
Okay, but you certainly told our investigator a lot of things Janet told you just didn't seem to match up, correct?
There are some inconsistencies in things that she has said.
Now, did you believe any of the money you donated was to go to medical expenses?
No, I did not.
Okay, you thought it was for general living expenses?
Yes.
Because they were impoverished, right?
Yes.
Yeah. Okay, and did you know the contractor that went to their home to do the work on the room?
Yes, he was my contractor.
Did you actually refer him to them?
Yes, I did.
Okay. Okay. Would it be accurate to describe what you saw Michael Jackson had provided Gavin at the hospital was a large display of gifts? Does that sound accurate?
It was in keeping with what I had done. I wouldn't consider it overly large.
Did you see a lot of gifts from other celebrities at the hospital for Gavin?
It's possible that I did, but they were celebrities that I knew. And Michael is a huge star, so that would have stood out in my memory.
Okay. And you remember very clearly seeing what he had sent, right?
Yes.
And did you discuss with Gavin that Michael Jackson had sent him a large gift display?
I saw the big gift basket and I said, "Wow, who sent you that?" And he said, "Michael."
Okay.
And I was impressed.
Do my ears deceive me, or did this witness just actually compare Michael's giving to hers and didn't seem to be impressed? Well, we'll deal with that in just a moment. As Mesro continues, he doesn't seem to be impressed about how this witness reacted when she thought the accuser's family was being held against their will.
Now, after you had your phone call with Janet where you thought she was scared, you said you called your lawyer, correct?
Correct.
You didn't call the police, did you?
No, I didn't.
You never called the police about anything Janet told you, correct?
Right. Correct.
Do you know anything about Gavin's behavior at his school before the year 2003?
Yes. One of the teachers came to the hospital to visit him, and she joked about it.
Do you know, for example, whether or not Gavin was repeatedly disciplined by virtually every teacher at school?
I think he was chatty. You know, we joked about that he talked a lot.
Did you ever look at his school records?
No, I didn't.
Do you know anything about him fighting in school?
No, I don't.
Do you know anything about him getting up in the middle of class and starting to sing?
Objection, relevancy.
I think it's been opened, Your Honor.
Has no bearing on credibility.
The objection is overruled.
I don't know anything about that, no.
Do you know how many teachers disciplined Gavin at his school, if any?
No, I don't, other than it had been discussed in a joking manner by a teacher that came to visit him at the hospital.
Do you know whether Gavin was often sent to detention at his school?
No, I don't.
Do you know whether he called teachers names?
No, I don't.
Okay. No further questions, Your Honor.
All right, Howard, where is the choo-choo, Howard, that you repeatedly talk about? Question, do you know, for example, whether or not Gavin was repeatedly disciplined by virtually every teacher in the school? Silence from the prosecution. I think he was chatting. She goes on to describe her impression of his school problems. But Mesro's not on his feet going, wait a minute, every teacher in the school? Come on.
I would have asked the question differently. What I would have asked is, if I told you that Gavin was repeatedly disciplined by virtually every teacher at school, would that have made a difference in your opinion with respect to Gavin, or whatever word you want to end it off with? And her answer really has a different impact, and I guess it's just a difference in style.
Well, maybe a style point, but maybe a substantive point, Ricky, with respect to what this witness brings to this testimony. She's not impressed, going a couple of clips back, she's not impressed with what Michael Jackson gave to this kid. Who cares?
Well, I think we don't care about that, but I think we do care about this. We sit here as 4 lawyers sitting here in Los Angeles. You've got 12 jurors up there in Santa Maria who may have a whole different feeling about this, depending on what, as I would say, they bring into the party, they bring into the jury box. And if they sense her feeling that this family, this sick boy, this boy who had cancer, was taken advantage of sexually by Michael Jackson, they may gravitate toward her.
They may, but gee whiz. All right, Sean, I know you're ready. We'll get to that thought when we get back. When we return, did the accuser's father hope to have a closer relationship, if you will, with this witness? Stay with us. I'm James Curtis. Join me as E! News puts you in the middle of courtroom action at the Michael Jackson trial.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. On redirect examination, Assistant District Attorney Auchincloss sets up the following scenario. The bad dad was out of the picture before the family accused Michael Jackson of illegal behavior. Here's what the jury heard according to the courtroom transcripts.
What is your impression of the powers between Janet and David?
That she was very intimidated by him, and that after he was gone, she could tell me the truth, and so could the children.
How much time, how long have you known the children since David left? I guess the better question would be, how long has it been since David left that family?
Gosh, it would have been, what, like 2001 or 2002, so 3 years since then?
Is the family different?
Oh, yeah.
Since that time?
There's a weight lifted from them. They're almost joyous. When I'm in their presence, they're laughing and joking, easy to be around.
You also said something about celebrities or famous people being a lifeline to this family.
Yes, I did.
What did you mean by that?
It felt to me like Janet was reaching out to people who were more stable so that they could pull her out of her circumstances and help her stabilize herself. Like she was almost desperate for stabilization or to rescue her children from this situation. The more people that she let know, the more likely she would be able to get help for herself and her kids.
All right, y'all catch that? People with money and who are famous are more stable than people who don't have those things. Now, more damage control by the prosecution.
Now, specifically, you've mentioned 2 occasions, I think, that you thought the children were coached. One involving a computer.
Yes.
And another involving when Star was coached. You felt he was coached about saying he just got love for Christmas.
Yes. And as soon as David went down to the car, Gavin told me the truth.
Okay, let's talk about that. Tell me the circumstances of that second incident.
I called to make sure they were there because I wanted to bring them my presents for Christmas. And I said, "What else did you get for Christmas, Star?" And he said, "Just love."
Now, were you in the room at the time?
No, I was on the phone.
Okay.
To make sure they were there before I came down.
And this was at the hospital?
Yes.
And Gavin's hospital room?
Yes.
And so you're talking to Star, and you ask him this question, and he says what?
Just love.
And that sounded what to you?
It sounded coached.
Okay, but did you know it was coached?
No, I didn't know it.
It just sounded funny to you?
It didn't sound like something a child would say, unless they say that in their family, unless it's like a family thing, that's what they say.
Okay, but in fact, did you ever see any coaching going on?
Never.
Have you ever seen Janet under any circumstances where you believe she was teaching her children to lie?
No, never.
Have you ever had that impression?
No.
Sean Chapman Holly, please disregard, and I apologize for my editorial outburst in between those 2 pieces of tape that we just saw.
Don't apologize. Go with it.
Let's go with it. Give in. Let's deal with the nuts and bolts of the cross-examination, though. Nice try or good save on the part of this prosecutor with respect to rehabilitating this witness.
I don't think that he does a good job of rehabilitating this witness, because I think this witness's bias is so transparent. She's not willing to give any credit at all to Michael Jackson. She's going out of her way to say everything that's going to be good and positive for these kids and for their mother. And really, the redirect just does more of that, demonstrates that even further. So she's a biased witness, and that's all there is.
I agree 100%. She actually concedes, without realizing what she's doing, that there's a direct link, lifeline, take her out of her situation with the money. So it clearly sets the stage for what the defense is going to argue. And secondly, it's interesting. She says she never saw them coach and never saw the mother teach them how to lie. Well, why would the mother do it in front of this lady?
Of course.
She's part of the con.
Well, if that is indeed true, that's certainly a defense position. But, Ricky, I see a little head shaking.
No, but I think you have to take it from the prosecution point of view as well. Here we have not only this witness, but we also have Fritz Coleman. We can't forget the weatherman.
Because they work together with respect to the gift giving.
They are people who cared about this family. They saw a family who was really poor, virtually destitute in the way that they were living, that has a young child at the age of 10 who gets cancer, who winds up in a hospital bed, could possibly die, and it breaks their hearts, and they want to help this family, and they look at that mother as a woman who suffered from abuse, who is trying to hold a family together. And there's a lot of jurors who are going to accept that.
Absolutely, and while all that is true, in the wake of what they may view as dishonesty, that is Fritz Coleman and this witness, Ms. Palanker, do they now feel a little had? Well, on re-cross-examination, defense attorney Mesereau puts this witness on the spot.
You made a comment that you thought Janet had suffered from hostage syndrome since she was 16, correct?
Yes.
And it was your understanding at the age of 16 she married David, right?
Right.
And you also talked to Janet about her upbringing, did you not?
No, I don't think I did.
Did she tell you that her father had beaten her and held her hostage too?
No, she didn't.
Objection, no foundation, irrelevant.
Sustained.
Now, the prosecutor, excuse me, let me rephrase that. Did you have a lot of discussions with Janet about her upbringing?
Not really, no.
But you certainly had enough discussions to conclude that she's had this thing about being held hostage since she was 16, right?
That's when she got married.
Right, okay, all right. Did she ever describe her situation as like a hostage syndrome since the time she was 16?
She didn't use those words, but that's what she described.
Next, a startling revelation about why the accuser's father made this witness, Louise Palanker, so uneasy.
Have you ever had any discussion with David about his side of this story?
Yes, I have.
And when did you last talk to David about his impression of what was happening in the family?
It was about 2002, right after he had lost custody of his children.
And David was complaining about not having custody of his children, was he not?
Yes, he was.
He was complaining that Janet had told the children what to say, wasn't he?
No.
Objection, hearsay.
Sustained.
Where did you have a discussion with David?
On the phone?
Did he call you?
Yes, he did.
Did you ever have any discussions with David about Janet coaching the children?
Objection, hearsay.
Sustained.
How long was your conversation with David?
Very short. I didn't want to be in the middle of that domestic situation.
But in a sense, you ended up in the middle, sort of, didn't you?
Yes, I have.
You did because you've become a good friend of Janet, right?
I wouldn't classify it as good friends.
Well, certainly more friendly than with David.
Yes.
Because David offended you, didn't he?
To a certain degree, he did.
You thought his comments to you were very inappropriate?
Yes.
You thought he might be interested in you?
Sometimes, yes.
For a relationship, right?
Yes.
And you complained about that, true?
I didn't complain to him about it.
But you complained to others about it, did you not?
Maybe to a couple of... I think I told Jamie that I didn't want to be left alone with him again.
Right, right. And needless to say, David never was a close friend of yours, correct?
No. He wanted to be, I think.
And when did you last see him?
Probably the last benefit.
Ricky Kleeman, a great point for bias on this witness's part. Now, not the dynamic between Michael Jackson versus the family, but the intrafamiliar, if I'm using that word correctly, dynamic between husband versus wife.
Yes, I have to say, because we know how I think of Tom Mesereau. I think he's one of the great cross-examiners of all
Certainly.
time, and this is the kind of thing he does so well. What happens here is he's basically saying, of course you're taking Janet's side of the story because David was hitting on you.
Yeah, and
you don't like it, and so you want him away from you. It's a beautiful piece of cross.
But is it effective, Howard? It's a nice piece of cross, but is it worth its weight in testimony, if you will?
Howard is the greatest cross-examiner.
Absolutely.
But that's because, I'll say that because of DeLorean. I mean, people can learn from reading your transcripts.
Yes.
I think this witness has shown such a bias that if Tom Mesereau couches his cross-examination, he's done a pretty good job here, I think, to show that bias. The jurors have to believe this witness is going out of her way to justify lies, to justify an unbalanced mother who she says is bipolar, to justify excessive phone calls and letters to celebrities for money and gifts. She excuses all of that.
But, Sean, Ricky's point, I think, is one that's very well taken. You have a child who's stricken with, heaven forbid that any of us have that affliction, let alone our children, and this mom, perhaps not very sophisticated, is just doing the best she can.
She may very well be doing the best she can. That doesn't change the fact that we keep coming back to the same thing. It's all about the credibility of two kids, Gavin and Star. It's the he said. And if this mother has got these problems that we're seeing, and the father, too, has some different problems that are similar, and they're influencing these kids such that they're not credible, well, then we can only really draw one conclusion.
Well, but
is
it only going to be one conclusion? That's the point I think that really gets to all of us. Can you have the scenario where, yes, mom is maybe not the best person in the world, but does that mean that this child was not abused? When we return, the courtroom becomes a battleground over pornography.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. The courtroom becomes a place not fit for kids or apparently adults either. With no jury present, Assistant District Attorney Gordon Auchincloss asked Judge Melville to let the jurors see all of the adult material found on the King of Pop's computers. Here's what happened according to the courtroom transcripts.
The bottom line here is that this is circumstantial evidence that this defendant views teen pornographic or erotic materials on computers in his bedroom, which is one of the most important aspects of our case. And as you know, in these cases, it's always a matter of credibility of the young victim. So corroboration is always highly probative to show that these young victims, when they're telling the truth. And I don't think you can just say it's a coincidence that these materials are on these, all three of them, and all in his bedroom, and all seeking the same sites.
Probative, that legal term, meaning it proves something. Next, defense attorney Robert Sanger insists that there is no way to determine who took the erotic journey through cyberspace.
But looking at the material, it appears that there's nothing whatsoever from the time period involved, number one. Number two, the type of material is such that it is not probative in this case. It is cached material. That is, material that was caught by the computer because somebody had opened a photograph. And it could have been by an email. It could have been by virtue of somebody surfing the web at a particular time. And it's heterosexual material. And it is not directly related to this case. Thirdly, the issue of who accessed the material is totally unresolved. There's no way to determine who was using the computer to access this material in November, September, October, November of 2003, or back in 1998. So there is no probative value if you cannot link that directly to Mr. Jackson or somebody else in this particular case.
And what happens here ultimately is Judge Melville Howard sides with the defense. Where is the train? And says, no, it can't come in because of the reasons that Sanger noted. One, it's not the right time period. It doesn't fit with the time that they were there. And it's adult stuff on there. So doesn't that show, for one, Howard, well, first of all, let me back up. Do you agree with the ruling?
I do agree with the ruling. Not surprised, because they have gotten a lot of pornographic references and adult material references and computer references already in front of the jury.
Absolutely. Now, let me just stop you there, because I don't want to leave you on that point, because you agreed with this judge. So, Sean, doesn't that mean that Howard's just a little over-enthusiastic about this train and this judge having a set agenda with respect to this trial?
No, because one of the things that we didn't talk about in the earlier testimony is the judge sustaining objections of hearsay when this witness, Palanker, had testified repeatedly to hearsay on direct. And
you
as
were
soon
looking
as
at
she
my
starts,
notes earlier, weren't
no,
you?
I have
made
this
the very
note
same
right
note.
here.
Yeah.
So, no, the train is still on the track.
The train is still on the track. Go ahead.
No, this is a really important ruling for the defense. This is a huge ruling, much more important ultimately than the hearsay ruling, because what we're going to deal with there is either the prosecution or the defense is going to call the father and the mother.
Exactly.
We're going to see the father and the mother. But this is really important because jurors would get to view this pornography on these computers that can have an enormously prejudicial effect against Mr. Jackson.
And isn't that really the bottom line? Even though that objection was sustained and maybe it wasn't the correct ruling, that Louise Palanker didn't get to continue to testify about what other people said to her, hearsay, the question's out there. So isn't that the benefit to the defense? When you ask the question, it's in the juror's mind, no?
This judge is pretty smart. Most of this material is in front of this jury anyway. I think the district attorney's office, if they've achieved a bias in this area, they're already there. What frustrates me most about this case to date, the issue is, were these kids molested? And what we see is a mountain of evidence to attempt to smear Michael Jackson so that the jurors look at him in a negative light.
But isn't it a little relevant? Come on, guys. Isn't it a little relevant that there are pictures in Michael Jackson's possession that have to do with young-looking porn stars, for lack of a better word?
It's even it's also relevant that he has pictures of adult women, because the expert has testified for the prosecution that using heterosexual material, sexually explicit material, even of adult women, gets the children in a little bit of grooming, but
desensitizing. Yes, we'll continue with this debate for weeks, I bet. We pick up with Detective Craig Bonner on the witness stand on cross-examination. Defense attorney Tom Mesereau asks Bonner if he found proof that the accuser or the accused actually handled any item of the adult material located in the infamous briefcase.
Do you know if any of the materials that you've identified today were DNA tested?
I know that items within 317 were sent off to the Department of Justice laboratory to ascertain if there were materials on the items which could be tested for DNA.
And just for the record, item 317 is what?
I'm sorry, it's the briefcase that had these materials in it.
Okay, and to your knowledge, there was no DNA found, correct?
That is correct.
And you're talking about DNA testing of the briefcase, correct?
Of the materials within the briefcase.
Yes. Are you talking about the briefcase itself, too?
No.
Okay. And what you're saying is no DNA of Gavin or Star or any were found, correct?
No DNA at all, including theirs.
Is it a big deal? No DNA found. Do we really care? Is it important that it was tested?
It's not important, but it's probably important to the jurors, because these jurors are used to, as all of us are now, to seeing CSI and all sorts of police dramas, and they have an expectation of what you're supposed to find in this kind of case. And DNA, fingerprints are some of those things. And if there's no DNA, the jurors may attach significance to that.
They may attach significance to it, but is it the wrong type of significance in that it really doesn't matter if there was DNA or not? You wouldn't necessarily expect DNA to be on this kind of stuff.
Well, what they really want is they want the kids' DNA on the same pornographic material, adult material.
Thank you. Objection sustained.
Thank you. And they want the kids and they want Michael Jackson on the same piece. And that would help corroborate.
But realistically, unless the kid licked the thing or cried on it or some other bodily fluid or even an eyelash with a hair follicle on it, you're not going to find any DNA on a magazine.
Well, fingerprints.
You might if he was supposedly handling it, or if Michael gave him to look at it. And
more likely fingerprints, though.
More likely fingerprints.
Which there weren't any of those. Well, I think there was one of each. And there's an argument there as to whether or not they came from the grand jury testimony or the grand jury hearing and handling it there. So that doesn't get the defense
Well,
or
Sean
the
hits the
prosecution
nail
anywhere.
on the head, though. Because of CSI, because of forensic files, because of programs like that, jurors want this. And the question, of course, is reasonable doubt, isn't it?
Yes, it is reasonable
See the
doubt
Robert
all the
Blake
time.
verdict.
Yeah, well, and we'll talk about that because that actually plays into this trial testimony we're going to hear in just a moment. But when we return, how exotic is the erotic? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. While Michael Jackson may be a connoisseur of pornography, is that a crime? And just how much does this Detective Bonner, who's testifying now, know about where and how to acquire these so-called adult material? Here's what the detective told the defense attorney, Tom Mesereau, according to the courtroom transcripts.
Now, you've identified a lot of what appear to be commercially produced adult material, right?
Correct.
And all of it appears to be commercially produced for the most part, doesn't it?
For the most part, yes.
And all of it appears to be the type of material you can lawfully purchase, correct?
Depends.
Well, you can go to most magazine stands that sell this kind of material and find thousands of magazines that you can buy like that, correct?
Yes.
Okay, and it goes without saying, Mr. Jackson is not being charged with possessing or anything related to this kind illegal adult material, is he?
We have not charged as such, no.
Okay. Have you actually checked to see if you can find these magazines available in a commercial market type of situation?
No, I have not.
Have you gone to newsstands to see if you can find this material available at newsstands?
No.
Have you ever made any effort to find out where you can actually go buy this stuff?
No.
Okay. And you don't know where a lot of this material originated, correct?
I do not.
Is it true, based upon what you know, that no fingerprint analysis of item 470, the black briefcase and its contents, was done till approximately 1 year after the search at Neverland?
That sounds about correct.
Okay. Were you involved in the decision to wait that long
No.
to test it? In fact, those items in 470, the black briefcase and the contents, were not tested for fingerprints till approximately November of 2004, right?
I know what happened after I checked it out.
Okay, okay. Now, you appear to have focused on item 470 more than you did a lot of the adult magazines you discussed today, correct?
What do you mean by...
Well, you seem to have been handling and repackaging 470
Correct.
in a way that you were not with a lot of the adult material that you referred to today, correct?
Correct.
All right, let's go down the line and around the horn. Ricky, start us off. Final thought, and who's ahead at this point?
Well, I think that the prosecution is coming back up because I think that they suffered a great deal at the cross-examination of the young accuser and of his siblings. And I think what they're trying to do now is take little bits and pieces to corroborate, that is, show that the kids were telling the truth. And that's the kind of stuff that makes a juror say, aha.
If it works. Howard?
Well, I just want to point out one thing on Mr. Mesereau's cross-examination of Detective Bonner. He asked him, and it goes without saying, Mr. Jackson is not being charged with possessing or anything related to this kind illegal adult material. The response was, we have not charged as such.
Yes.
My
What's that
follow-up
mean?
question would have been, you haven't charged it because he didn't possess any illegal material. Isn't that correct, Detective? The answer would have been yes. I wouldn't have asked him another question about any of this, and it would have put this testimony in perspective.
Possibly in his possession, because that's one of the big issues. Did he actually possess it? Was it his or not?
Doesn't matter. He could possess it. It's legal.
That's correct.
Exactly. Even if it was, there's no crime here. Sean?
I just was thinking about what you said earlier about the Blake trial. It really comes back to, as we've seen in that verdict, that jurors are looking at the credibility of the prosecution's witnesses. That's really the key. And that's what this comes down to. All of this is one thing, but it really comes down to that, I think.
What's the prosecution going to do next? Are they about done?
Well, we have to know the big day. Are the prior allegations coming in, 1993 and 1994? In which case, we're spending the summer right here.
Yeah. And if that doesn't come in, it should wrap up pretty quickly, no?
They should be done.
We have to do false imprisonment.
All right, we have to leave it right there. Be sure to watch our exclusive Michael Jackson trial coverage weeknights 9 p.m. right here on E! And for a sneak preview of tomorrow's reenactments, oh yeah, go to eonline.com tomorrow at noon. See ya.